All rise. The Court of Appeals Division 1 is now in session.
Morning. Please be seated. Good morning. We are here for oral argument in consolidated cases CV220167 and CV220289. Jurju versus, is it Ile? Ile,
Your Honor.
Ile. Thank you. Okay, Jurju versus Ile et al. As you may know, we record and are currently live streaming these proceedings. So when you stand up, please introduce yourself and the clients that you are here to represent. You have a maximum of 20 minutes per side. We do not require you to use all of that time, but it is available to you. You do need to keep track of your own time, particularly if you intend to use some for rebuttal. I think that is all of the housekeeping. Please keep in mind we have read the briefs, we have reviewed the record, we have conferenced the case, and with that, please proceed.
May it please the court and counsel, my name is Brad Owens. I'm here representing Florin and Anka Ile and their company Paradise Valley Senior Retreat LLC. This is the consolidation of the two appeals, and I would like to reserve at least 7 minutes of my time to respond to the injunction appeal and to reply to the eviction appeal. The way things have been set up here, I think that's the best and cleanest way to do this going forward. The overriding theme of these two appeals is how can an eviction be appropriate against one claiming ownership in the subject property, since the eviction action can't look into ownership. And that's the underwriting theme throughout all of this, and where the Iles are coming from, and where the great disparity exists between the positions of the parties. As part of the eviction action, there was a complaint filed on November 3rd, I believe, for the eviction. On November 4th, there was a civil action filed that we'll get into later, but included injunctive relief and a quiet title action and so forth. But at the eviction hearing, in the initial appearance, that was a 6-minute hearing. And through the Ile's motion to dismiss at the hearing, and then again in their motion, Rule 15 eviction procedure rule motion, they alleged and raised various issues that merited a trial on an evidentiary hearing, so that the Iles could come forth with evidence, as they did in the civil case, which we'll talk about later, which outlined the basis and their rights to the property and to the partnership.
But weren't those issues not properly before an eviction court proceeding?
That's true, Your Honor. And they're not. And I think all the parties agree that an eviction action is simply a proceeding to determine possession of property. But where it cannot get into the ownership or the partnership or the business arrangements, we have set forth in our brief all of the numerous case law that says that these are prerequisite issues before we can decide possession of the property. These issues must be determined first. And instead of allowing the Iles to present this evidence and firm up their allegations, the court did not order an evidentiary hearing or a trial pursuant to Rule 11C 1.
Counsel, I want to talk about kind of the tolling issue and the tolling of the time. Okay. Wouldn't you agree that the text of RCAP 9 doesn't permit tolling the time to file an appeal from the eviction?
Yes, that goes to the jurisdiction argument, which I can address. And it is an elephant in the room right now that we've gone through, and we believe that the Sotomayor decision was wrongly decided, and it was flawed or incomplete in its analysis. And we've set forth in our reply brief to the response that there are a number of reasons for that and why it should not be followed.
But just to confirm, if we were to say we are not willing to part ways with another panel of this court from that case, and we are going to rely on the plain text of the rules at issue, which don't include the eviction rule 15 as a time extending motion, that we would not have jurisdiction in that case over the FED action. Is that correct?
You would not have jurisdiction if all you're looking at is the Sotomayor decision and you follow that. That's a Division II opinion, and you follow that exclusively.
Well, to clarify, the Sotomayor opinion relied on the text of the rules. So
correct.
I guess what I'm saying is if we were to say we also would find ourselves constrained by the language, the plain text of RCAP 9 and the fact that Rule 15 is not included as a time extending motion. If we find ourselves constrained by that plain text, then we do not have jurisdiction. Is that correct?
Over the eviction part of this appeal and the possession of the property issue, I would have to agree with that, but there are a number of reasons why this court should not do that, and that's because Sotomayor did not take into account all of the issues and distinguishing facts and issues that we set forth in our brief. And Sotomayor also went on that court and said that the Rule 15 motion is not appealable, basically. They came forth with a test that said Rule 15 motions are basically not appealable, and the test is if the Rule 15 motion raises issues that are different from those that would arise from an appeal, or if they raise issues that it would affect the judgment or relate to its execution, then there is no appeal from a Rule 15. So the strict application of the statute in that regard creates some real problems and some conundrums, as it did for the Iles in this case, because what they're having to do is choose. Do I file a Rule 15 motion, or do I appeal, and I waive my right to file a Rule 15 motion, how can I do that? Why isn't a Rule 15 motion appealable? Why shouldn't it be?
But even if the result is harsh, how can we ignore the exceptions that are outlined in the rule?
The court can find that there are, under the statute, that those matters can be generally appealable, that the judgment can be generally appealable, the Rule 15 can be generally appealable under the statute, not the rule. And what the rule has done, and as it did with the family law rule of procedures, they had to make an emergency amendment to solve the problem that was created by this gap where it didn't include, and what you have is a trap for the unwary, kind of a gotcha, where you think that that's a time extending motion or a deadline extending motion, and under the strict reading of the rule, you're saying, oh no, you're out of luck. Yes, you have a right to file a Rule 15 motion, but
what are we to take from the Supreme Court's decision to pursue that in the family Rule 83 context, to pursue the remedy of an emergency change to the rule and then rethinking all the appeals that this court had said, okay, we can't handle these because we don't have jurisdiction. So that's how the court handled it in the family side of things. They didn't say, well, we're going to just sort of as a matter of equity and fairness and the statutory language, we're going to find that it's okay. They didn't craft
and there was
that
a gap, and we addressed that in our brief. There's no cases that were published that deal with that issue, the gap between the changing of the rule and the effect of that, the emergency amendment to the rule, which said that, there is a time extending motion for under the family law court. That wasn't done with the eviction proceeding. That has not been done yet. And so what we're faced with is a rule that closes down what an aggrieved party can do to appeal a wrong judgment. And in this case, the eviction judgment is just plain wrong on many different levels. And we cite to those things throughout the brief. It was very poorly done. There was a lack of due process, a lack of hearing on the merits, 6-minute hearing, and lives are destroyed by that. So the eviction court went way beyond its authority in granting the possession of the property to the Jurjus, and they can come in and wreak havoc on the business, on the vulnerable senior adults there, and on the contracts there. None of that is within the authority of the eviction court, but the practicality of it is by ordering a change of possession here, all of that is going to be ruined. All of that is going to be upset, and we're going to impair a lot of senior adults that were not named as parties, so the eviction court had no jurisdiction over them.
Counsel,
Yes.
question on something you said early in your argument, if I heard you correctly. You said there are several cases that tell courts that they need to address the title issue before they address the eviction issue.
Yes.
What's your best authority for that?
That's a good question. I've listed it. The authority is the first one. It probably is the Tri-Colony case.
Thank you.
And there's a number of others that go to that. So, and that follow it. I could be wrong on that one. I remember reading so many cases, and I had to pick and choose from those. But I did list a number of them in there, and that is the nature of eviction actions, and that these are summary proceedings, and that we don't have room or time to do anything but possession of the property. But if there are legitimate issues, prerequisite issues like ownership, like a business, like a partnership here, and it was proven in an evidentiary hearing before the civil court, found likelihood of success in the merits, found a partnership, found that the Iles had an interest in the property. Okay, they were not afforded that opportunity in the eviction action. But because of the prerequisite issues, those things need to be taken care of first. And it was the Jurjus that elected to pursue an eviction action prematurely, hoping to undo all of that, hoping that they could just simply take over the business, kick out the Iles, take over the contracts, and move on from there, without any due process or evidentiary hearing whatsoever on behalf of the Iles to get what needs to be done. So that creates a real serious problem. And that is compounded by this odd appellate deadline issue where Rule 15 motion, a motion to set aside judgment, motion for new trial, well, motion to set aside judgment in this case is time extending in all these cases, but it's just not listed. The eviction action in Rule 15 is just not listed as a grounds for an appeal. So that creates a real serious problem. And again, it creates a trap. Whereas in every other case, that's normal practice, is that is a time extending motion that can be filed. And there's no warning lights or anything other than the Sotomayor case to kind of clarify that, no, this is what we mean because it's not listed. It's not one of the motions that can be allowed. Well, it technically is a Rule 59 and Rule 60C motion. All the grounds in the civil procedure rule, 59 and 60, all those grounds are listed in Rule 15. So it's similar, if not identical, to the grounds that are listed in there, yet we're treating it differently. We're treating it as go ahead if you want. There's no appeal from it. It doesn't extend the time.
Counsel, I appreciate you indulging me. I know we kind of flipped your order a little bit, but I wanted to discuss jurisdiction with you. I'd like to move, to the other issue now. So, assuming the multiplicity exception doesn't apply, would you agree that ARS 12-18021 bars the injunctive relief you sought?
No, I would not agree with that. The injunctive relief sought is on issues that were outside the scope of the eviction court's authority and jurisdiction. The injunction applies to not, prohibits Jurjus from interfering with the contracts between the residents and the Iles, it prevents them from evicting the residents because, again, they were not parties to the action. The eviction court had no authority over that. So I think the injunction civil action court was very careful in outlining exactly what could happen and what would not happen. And they allowed the collection actions to go forward. The court did, did not stop the judgment, but it did stop those issues that were basically prerequisite issues that the court had no authority to determine. And so the court, and if you look at the minute entry and some of the transcripts, the court was very careful to craft that injunction so that it did not run afoul of a prior ruling, which in this case is the eviction judgment. And I understand that the Jurjus are arguing that. Well, we have our eviction judgment, all these other issues go away, we can enforce it now. But then that creates the impossible injustice of the Iles not having the due process rights to raise those issues and provide evidence in a trial, which they did for the injunction hearing, all in a summary fashion, that the court can simply ignore that and say, well, all I see is this lease. And the judgment was entered, and it overstates damages, unpaid rent by $20,000. There are sanctions awarded against the Iles for filing an objection or a defense of the eviction action, but there's no addressing what those issues were, and yet they won. I mean, this is the disparity between the two rulings. On one hand, the eviction court said, no, you've got nothing, you're out of luck here, and we're going to sanction you and charge you double rent and do all these other things because this was frivolous and not made in good faith. And then you have the injunction hearing and that court saying, there's a likelihood of success on the merits. Yeah, and there's other factors, there's hardship, there's harm, there's public policy issues. You're entitled to an injunction. And found specifically that there was a partnership and that the Iles had an interest in the property. So how can the eviction court say the Iles are evicted from the property at the same time when the evidence adduced in the injunction hearing says that the Iles had an interest in the property? And that's the problem. That is the main issue here is how does that these disparate rulings react? And if the Jurjus were the first to the court and first to get the eviction hearing, they want all the rest of it to go away. We don't have to deal with that anymore. And that's the problem we're looking at. And that is the injustice that needs to be cured here, is that eviction judgment should be reversed and remanded and either stayed or dismissed pending these prerequisite issues. I would like to reserve the rest of my time. Thank you.
Thank you, counsel.
Morning, Your Honors. Opposing counsel, may it please the court. My name is Justin Clark, and I represent John and Livia Jurju. Before the court this morning is a very simple question in our opinion. We have an injunction that was issued by a civil court, a superior court in a civil action, a quiet title action, and we have an eviction judgment issued by a superior court in a detainer action. Now, the detainer action judgment came before the injunction was issued. The underlying eviction case was filed before the civil action was filed. It was filed it was a day before. There were some procedural motions that took place in the eviction action, but ultimately the court issued a judgment. Now, the judgment came a couple hours after the civil action issued in the injunction. The judgment in the eviction action came a couple hours after the civil action court issued their TRO. But our position is that is of no moment because the statute is quite clear. Statute 1802 states that an injunction shall not be granted to stay a judicial proceeding that is pending at the commencement of the action in which the injunction is demanded. Now, quite clearly, the eviction action was pending at the time that the civil action was even commenced and when the judgment was issued. And for that reason alone, we believe that the eviction judgment should stand and the anti-injunction statute, for that basis alone, should operate.
Counsel, what's someone like the Ile is supposed to do if they lose an eviction action, but they're running a business? What are they supposed to do to stay in if they're challenging title? What are their options once they lose eviction?
Well, an eviction action is quite straightforward. It's a summary proceeding. It looks only at the issue of possession and whether the landlord was entitled to possession. In fact, that's why the eviction rules procedure are so brief and so concise. Because if any party that contested title in an eviction, and I would argue quite a few would if given the opportunity, these proceedings no longer become summary in nature.
So they would be evicted and then they could still challenge title, but from away from the property. And
exactly.
Their businesses, they got to move their business out. There's nothing they can do, is that what you're saying? As far as to continue their day-to-day operation of their business once they've been evicted?
I think the tenants in that case would have every opportunity to continue their business, just not on the property that they were occupying. And now in this case, the Jurjus did everything they could to give the Iles advance notice. In fact, I think they even gave them a 60-day notice in July of 20, I think it was, yeah. In July of that year, they gave them a 60-day notice and they said, we would like you to move out. We're terminating our lease. And the Iles, they understood. They said, okay, thank you for the advance notice. And somewhere along the lines, the Iles weren't content to move anymore. And that's when they decided that they were going to stay and that they were going to challenge the Jurju's claim to ownership. And that's just not something you can do in an eviction action. I think there's case law that's quite clear on that. I know the appellant cited the Benjamin Franklin case, but I don't think that case has any applicability here whatsoever. That was anything but a straightforward landlord-tenant relationship.
Let me ask you, so your colleague had referenced the Colonial Tri-City cases, probably right. Best authority that if there's in an eviction action, if there's also a challenge to title, that the court's supposed to tackle the title issue before they get to the eviction issue. Is your colleague's argument correct? Is that what Tri-City tells us?
I don't think Tri-City tells the court that it has to allow an eviction action to always include.
I'm not talking about include. I'm talking. There's two different issues, right? There's the title issue, the eviction issue. Two different actions.
Yes.
So, is the Superior Court supposed to tackle the title issue first? Then, is that what case law tells us before they get to eviction, or not?
I don't think the case law states that. I think what the Benjamin Franklin case, and I'm calling it Benjamin Franklin, but it's Colonial Tri-City.
Same case.
Right. I think what Colonial Tri-City says is if there's issues pertaining to ownership that an eviction court cannot resolve, in other words, there's questions about the arrangement itself between the landlord and the tenant, then that is not a proper dispute for an eviction court to preside over. Now, in the Colonial case, there were some conflicting facts over the issue of ownership. There was a lease agreement, but the lease agreement had been assigned. And I think the issue there was, can the landlord go after a tenant who has assigned his interest in the property to a third party? And I think that is the key to that case that is lacking here. Here we have a lease agreement. It was signed by the Iles and the Jurjus. It was for a term. It was for a 3-year term, but it had a month-to-month clause in it. And the moment the term ended, the month-to-month took over. And that's the relationship the parties had for 13 years. and the Jurjus were at liberty to terminate that lease agreement whenever they wanted to. And that's exactly what the eviction court found. So while the Iles might claim that there are title issues in both the house and there's a partnership dispute in the business itself, those issues were not properly before the eviction court. And the eviction court reviewed the evidence that was offered. They looked at the lease agreement. They looked at whether Mr. Jurju was a title holder, and he was. And they made the decision on that basis. And that's precisely what the eviction statute tells the eviction court to do. And to protract those proceedings would effectively nullify the entire eviction
But then your position
statute.
is the civil division that has the title case issuing the preliminary injunction that was error.
I'm sorry, could you state that again, Your Honor?
The civil division
Yes.
that has the title dispute, it was error for them to issue the injunction that they did, correct?
I think, given the timing of the entry of that injunction, yes, because it goes against the anti-injunction statute. The eviction action had already been filed. It was pending. There was a judgment. The only thing left to do was the eviction court to issue a writ of restitution, which hadn't even been done yet. And that further indicates that the proceedings in the eviction action were still proceeding. So no matter how you slice it, the eviction action filed by the Jurjus predated the civil action. There were active issues that the eviction court was still dealing with when the civil action both started and also when the injunction was issued. And for those reasons, the injunction should not be allowed. It should be vacated. I know that there were some questions from your honors about Sotomayor, and that goes to the jurisdictional, obviously the jurisdictional issue here. And we would say quite simply, I mean, Rule 9A tells you exactly how long you have to appeal the judgment, and that is 30 days. That did not happen here. Instead, we had a motion to vacate. The motion to vacate did not modify the original eviction judgment, and it did not meet the other prong of the Sotomayor test. And to allow the Iles in this case to use a motion to vacate to basically put on hold or toll the time for the appeal, I mean, it would swallow the Rule 9A completely. And I think that's what Sotomayor found. And I don't think the Iles argument about Sotomayor being overruled would be good law. I don't think the court here should overrule it, because if you do that, you basically put the the eviction statute on its head. And these eviction...
Counsel, could I move you over to the injunction? Because I would like to talk about that for a few minutes. As I understand, Judge Ogney was aware of the anti-injunction statute.
Yes.
and she identified a distinction between enjoining an ongoing proceeding, which is clearly within the ambit of that statute, and staying the enforcement of a judgment. Can you talk to me about that? The statutory language doesn't actually, the anti-injunction statute specifically talks about not allowing an injunction to stop a proceeding, but it doesn't talk explicitly about the injunction to stay enforcement of a judgment.
Yes.
So what is your objection to that ruling by Judge Ogney?
So in our briefs, we cited the Sparks versus Douglas and Sparks Realty case, and essentially what we take that case to mean is you can't have the rights of suitors be dependent on mere forms or the decisions to depend on technicalities. And in our opinion, the trial court in the TRO basically fell into that kind of trap as saying, well, yes, the eviction judgment has been issued. It's not enjoining the judgment or the eviction court. It's enjoining the Jurjus. But if the injunction statute is taken to mean that it just prevents judgments from being executed, I mean, parties have to execute the judgments. Parties have to go into court, and they have to obtain relief if the judgment is not satisfied. So are we to then believe that if an injunction
I guess it would be helpful if you could tie your argument to the text of the injunction statute. Are you saying that this is just form over substance? Are you saying a proceeding and a judgment are the same thing? Are you saying we should read the word judgment into that statute?
Yes. So when we read the statute, we read it as injunction shall not be granted to prevent breach of contract. Oh, sorry, that's the wrong one. To stay a judicial proceeding pending at the commencement of the action in which the injunction is demanded. So in this case, we have an action. We had the eviction action. We still needed the writ of restitution. That had not been issued yet. So the injunction would function to basically cut short the eviction action because part of it had not been completed yet. So to have an injunction that's issued basically in the middle of an eviction action would fall squarely within 1802.
Well, what do you do with your colleague's argument that this was a very carefully crafted injunction? It was not just a broad prohibition of proceeding forward on the matter. It was narrowly tailored to prevent sort of the unfairness, I think, that Judge Williams was getting at, that you're going to take all these people and kick them out. When we have not yet gotten to the end of the civil proceeding, which could well sort of counter the effects of the eviction because title is at issue, quite title. Mm-hmm. So do you see what I'm saying? There's a logic to Judge Agnew saying, okay, I'm going to carefully craft this injunction to prevent what I see as a likely wrong because there is a likelihood of success on the merits in this quiet title action. Allowing enforcement of an eviction judgment would kick a bunch of people out when they may well have title to the property.
Right.
How do you address that?
So
position?
To that, I think our argument is that the eviction court had already found that possession was in the Jurju's name. And for the civil court in the quiet title action to basically go against that and overrule the injunction or the eviction judgment temporarily even would not be permissible. And that, again, goes against 1802 statute. And
well, I think you made the point earlier, the eviction action is about possession, not title.
Right.
The civil action is about title, not just possession. So it's not a direct, one-for-one overruling, right?
I would say it is, though, because the eviction court has to look at whether the landlord has title. And if we start to challenge title in eviction actions, then we get into the quagmire that I was referencing earlier, where eviction actions...
I'm sorry, that seems to be two contradictory things you're saying. You're saying the eviction court has to address title, but it cannot address title?
I'm sorry, I'm referencing possession.
Okay.
But title is an issue in eviction actions because we have to determine if the landlord is entitled or has title has the ability to evict tenants. And in this case, Jurju was identified on the deed that was provided in the eviction action. When you're in an eviction action, one of the questions one of the issues or elements is, do you as the landlord have the ability to evict a tenant? And eviction courts will look at whether there's a deed on the property. If the landlord has the deed under his name, that's one issue. If there's a lease agreement and the landlord is identified as the landlord in the lease agreement and has the ability to basically evict a tenant, then I think that issue is separate from title. Title is a much more detailed inquiry, and I think a lot of these other cases that we cited in our brief, if we look at the Casa Grande Trust case, for example, and Sunquest, those were all cases that involved questions about basically, I guess, who was entitled to ownership in the context of a landlord-tenant case. But even in those cases, I mean, the trial court where they granted an injunction were reversed because the trial court basically was acting in excess of jurisdiction when it denied a writ of restitution from being entered. So I think with that, even though the civil court tried to narrowly craft its injunction, our position is that it didn't. It still falls within the 1802 exception, and on that basis, the injunction should be vacated. I'm going to reserve the balance of my time to respond to the eviction judgment argument from the delays.
I think on the eviction judgment, this is your response. I think on the injunction, you can reserve time if you would like.
Okay, yeah, I will reserve.
Okay.
Fine, thank you.
Just briefly on the anti-injunction statute, and I don't want to repeat myself on it, but it's clear that the eviction judgment cannot affect the residents, the senior residents that are there. They cannot be evicted. They were not parties to it. So by enjoining the Jurjus from going in and either evicting them or removing them or somehow interrupting their lives and their care, that is outside the eviction court.
And what's your best authority for that?
It goes to the jurisdiction, which is back to the tri-colony and other cases that the parties agree that possession is the only issue in an eviction action. And number two, none of these residents were parties to the case. So the judgment cannot impact them. And so the Jurjus have no authority to evict these senior residents. They didn't name them. They didn't include them. They didn't give them notice. So there is simply no jurisdiction to be able to go in and tell these people that they have to leave. Likewise, the eviction court is limited jurisdiction. They can't come in and say, well, these contracts that you have with the Iles for your care in this facility, we can't address that. The eviction action only addresses possession, so you cannot interfere with that. So neither of those were under the purview of the eviction judgment. And so they can be enjoined. The Jurjus can be enjoined for pursuing that and from interfering with that. It was the Jurjus that selected the eviction action, prematurely, I think, but they did not include the rest of the parties. They did not include anything else. And so that's why the injunction judge was carefully crafted, that injunction. So it did not enjoin the proceeding, but only enjoined the Jurjus from pursuing that which they wanted to have with the eviction judgment, the right to go in, take over the contracts, kick the Iles out and take over the business. I mean, that's exactly what happened here, and the judge saw that this was not right, that the Jurjus had kind of run roughshod over the Iles in this respect. And she was simply trying to preserve the status quo pending a resolution of these prerequisite issues. And then it would have been appropriate to do an eviction action if it was found that the Iles, in fact, had no interest in the property and there was no partnership. But, of course, she didn't find that. The Iles were only required to put forth allegations. They did more than that. They put forth evidence in the eviction proceeding. But all they had to do was come forth with allegations. I mean, even the rule refers the court to look at the answer or ask questions of the defendant to see if there are any allegations or basis for a legal defense. And the court failed to do that here. We would ask the court to reverse the judgment of the eviction court and remand it with instructions to dismiss or to stay it, pending these prerequisite issues determined by the civil court. We would also ask that the injunction be upheld based upon the extent of the evidentiary hearing and the evidence that was taken and the witnesses that were heard. And it does not.
Thank you, counsel. Your time has run.
Thank you.
All right. In the Jurju's position or opinion, I think that the problem with the eviction, not the eviction, the civil court injunction is that it isn't narrowly tailored to the situation of preserving the status quo. By its very nature, it denies Mr. Jurju the ability to possess the property, and that cuts to the core of the eviction judgment.
What do you do with your colleague's argument that the Jurjus failed to name any of their residents in the eviction proceedings, so they can't enforce a judgment to evict folks who were not party to the eviction proceeding?
Well, I would say that cuts against one of the Ile's own arguments for staying the eviction judgment in the first place. If one of their issues is that the elderly patients are going to be moved, well, if the eviction judgment didn't apply to them, and that's not our position, we think it did, because it states as much in the judgment, the eviction judgment.
Isn't their argument based on exactly that? If your position is we can go enforce this to kick the elderly patients on a moment's notice out of their homes, despite them not being parties to this eviction judgment, if that is your client's position, then isn't it reasonable for the Iles to have said, well, we don't think they're party to it, but we'd like to stay the effect of it because the Jurjus are going to, get law enforcement and try to kick these folks out of their homes?
If that's their position, then the argument that the injunction was narrowly tailored is not well taken, because the trial court, or the TRO court, could have said, we're only going to grant Mr. Jurju possession, which would be consistent with the eviction judgment. We're not going to let Mr. Jurju remove the residence. We want him to basically come in, and the Iles will not be able to preside at the property or occupy the property, but Mr. Jurju is granted possession. The residents have to stay there, and the service agreements between the residents and the assisted living facility had a 30-day termination notice anyways. So that situation with the residents being removed was already accounted for. But to the extent that Iles argue that the eviction judgment should be basically, we would say, denied in wholesale, if you're the trial court and you say Mr. Jurju cannot have possession even, then there's nothing really left in the eviction judgment. And that's the problem with allowing the injunction to move forward. It goes against the anti-injunction statute, and it's beyond the scope of what the civil action court could have done. And for that reason, we ask that the injunction be vacated.
Counsel, I know you're out of time, but just one last question. So the writ never issued from the eviction court, correct?
Correct.
Because of the injunction.
Right, and that's the other problem.
Okay, and that's fine. I just wanted to know. Thank you.
Thank you.
Thank you, counsel. We'll take the matter under advisement and issue our decision in due course, and we will recess now to reset for the next argument.